a panel discussion entitled Main Legal Risks and Challenges with LLMs and Generative AI Models. We have already on the stage our dear speakers. I would like to present from right to left Mr. Heiko Hotz, founder at NLP London, Mrs. Rania Wazir, co-founder and CTO at Livan.ai, Ms. Marija Vlajkovic, partner for data protection at Moravcevic Vojnovic i Partneri in cooperation with Schoenherr. I hope I pronounced it correctly.
Yeah.
And Mr. Dalibor, as a moderator, Mr. Dalibor Marinovic, member of Group of Innovation in Public Policy at Public Policy Secretariat for the Republic of Serbia. Thank you very much. Please give them a warm welcome. The stage is yours.
Hello.
Microphones?
Maybe it's okay? Yes. Thank you all. Thank you for coming on the most interesting panel on the data science conference. Thank you to our guests, and let's start from Marija. Marija, please introduce yourself in a few sentences, no problem.
Okay.
Before I ask you something.
Thank you, Dalibor. Thank you everyone for attending. Thank you for inviting us to participate in this one-of-a-kind event. My name is Marija Vlajkovic. I'm a partner in a law office, Schoenherr. It's an international law office, and I focus on IP and tech law. Obviously, IT and tech law and GDPR issues. Obviously, this is now interlinked with the AI, and that's why I'm starting more and more to shift to regulatory aspects of the AI, which are yet to be developed in Serbia.
Thank you, Marija. My first question for you, we talked in front of the Sava Center, the biggest Congress center in Balkan, I must say that.
Yeah.
There is a lot of hype about AI models, especially generative AI models, such as ChatGPT, Midjourney, Stable Diffusion, and others. And in your opinion, what are the main legal risks while training these models or when they are used?
Yeah. So I will be speaking from the aspect of the privacy law because obviously we have also collocated an event. This is in Pandora, and over there my colleague also from our office, Andrea Radonjin, and also partner for IP, will be speaking is actually speaking right now about the IP aspects of using the generative AI. But when it comes to privacy risks, well, there are many. In principle, the same as in IP. You're fed up certain model with a vast number of data. I just scrapped all the internet, including also personal data. Especially you have scraped the data from the social media accounts, and they're all in the, well, let's call it now ChatGPT, but any other generative AI model. So you have done that without a person's consent, an individual's consent whose data has been scrapped and used for training. Again, you have another layer of risk, and that is the output risk. So what happens when with the output, and that could be various bias and discrimination and stuff. But let's just start from the beginning. Why all we're speaking about the privacy issues as important issues, legal issues when using AI and when training AI models? Well, principally, this is just a huge amount of data we're speaking about. So particularly when we talk about ChatGPT, it's built upon 175 billion parameters. And as huge as the model is, the biggest the risk of keeping under control this data is. So, and that is practically what the legal risk in privacy is. When you can't keep under control your data, and when you have a loss of control, then you have privacy issues like breach of your data, misrepresentation, false identification, stealing of somebody's identity. So all this can happen when you have lack of control, and it's very hard to preserve this control when you have such a huge amount of data, such a huge system. At the end, of course, the AI Act and of course the bill of executive order of President Biden, they're all kind of focusing on cybersecurity, on implementing various security measures. That will be a challenge, that could be a solution, but we're still living right now in the moment when this all has already happened. So whatever we decide for the future could be a way to go, but we're still right now living in the situation when all our data, probably all of our personal data, if we have personal accounts in social media, are there and were used for training. So scholars are, on the other hand, dividing these models, these harms into objective and subjective, and into harms related to input or training of model and the output. So when we talked about objective risks, they're just subjective risks are like using my data without my consent, and objective risks are more like using my data without my consent, but with intent to do me harm, or like for example in doxing. When we talked about training models, as I said, for training a model based on my personal data, you should have my personal consent or another kind of a legal ground, because the GDPR is already in sort of a way regulating AI. It has certain general provisions about automated decision making and about data processing. Using data in training AI models is a data processing. So you can do that if you have a legal ground. And it is not only consent, it could be a legitimate interest, but this will hardly, this will hardly pass, because to have a legitimate interest, you must prove that your interests are they're overriding my fundamental rights and my fundamental interests and rights. And that is, you can hardly say that your interest to make profit is overriding my personal rights. So that is one of the issues. Another issue is just how, how to combat with this. You can't opt in, because the consent, if we now lean on the consent as a legal ground for using one's personal data to train a model, how you can, we obviously didn't give our consent, so there's no opt-in, which is a standard for consent under the GDPR. But can we opt out? Is that possible? How can we opt out? All this amount of data is over there. How you can find me and my data in this 175 billion of data and say, okay, you can now opt out. So I don't think that's really feasible, at least in these models. Of course, and probably people with more experience and technical persons could give input on whether reversible training or detraining of model is possible. That is something that is, in theory, data scientists say that is possible. But on the other hand, sounds very expensive and quite impossible to me, and unrealistic, let's say. Then we have various other issues, like how are we gonna actually enforce our rights? GDPR gives us rights, for example, right to be forgotten. How are we gonna, just say to OpenAI, oh, please delete all my personal data that have been used for training? So we come into this, let's say, situation when we don't know how will the GDPR and a new EU AI Act, once it's adopted, how will their interplay? How will we actually enforce some of our basic rights, like right to be forgotten? But that's just one of the rights. So I would say these are all the issues, and we don't know how this will kind of turn out. We are waiting for a EU Act to give us some more information about it, but EU Act is just saying, okay, high-risk systems that can produce risk to individuals, they just need to turn to GDPR, and GDPR then says, okay, you do have to perform a data protection impact assessment. And we're just, okay, that's what we know. But what we don't know is exactly what I said. How are we going to actually enforce certain rights? How is that going to work in practice? Have no idea. Whether that means like, okay, we do have a list of high-risk systems, but it seems like that actually EU Act is saying you have to produce or do the data protection impact assessment not only for high risks, but even for the other systems. That will all create a bit of confusion. I suppose that we will just have to wait and see how all this risk and, let's say, open questions will be dealt with in practice, and especially once we have adopted a final and adopted version of the EU AI Act.
Thank you, Maria. And it's crazy numbers. And
Yeah.
can you tell us where do we stand with regulatory framework? Not only in Serbia, just you
Yeah.
can tell us. USA, for example, or leading countries in the world.
Yeah. In USA, Biden has issued an executive order on the 30th of October, and it's kind of a list of basic principles. I wasn't really deep diving into it, but my main conclusion or impression was that they're actually more focusing about let's just introduce various amounts of cybersecurity measures and technical measures to avoid privacy issues, and they were not maybe that much leaning on resolving or giving particular solutions onto privacy issues and IP issues, which are, from the legal perspective, the main issues. So my impression is that they were actually trying to shift this over to the developers to make sure that they just implement the best possible techniques and cybersecurity measures to try to prevent any sort of leak or just abuse of our privacy. When it comes to EU, we have a kind of a drama. Whoever was following it, I mean, it's just hotter than any soap opera TV show that I ever watched. So one day is one thing and the other day is something completely new. Apparently we have a battle between all the stakeholders and these systems. Those are Council of Europe, European Commission, European Parliament, and each of the countries that are having certain influence are also kind of pushing forward to their solutions. And the biggest bottleneck is how to deal with the foundation models or the general use AI models such as the ChatGPT. So this is kind of now somewhere in the middle, and I think that they're all doing a bit of a trade. Also, some countries are pushing for actually excluding law enforcement use of the AI from the EU AI Act. The other ones are trying to push for the remote biometric identification systems as still being banned, whether they will be alive or ex ante. But I think that somewhere in the middle they're just juggling up and now trading with certain positions, and we can only just sit and wait. When it comes to the other countries, well, China has adopted a sort of regulation on the AI. They're having some sort of a less fair principle and approach. This happened around August, so they're kind of having an exception for the open AI models. And UK just had a safety summit, so we don't know whether they will shift their approach, but they also at the beginning had some sort of less fair approach, like pro-innovation and less rigid legislation, which could potentially, let's say, sort of hinder development of innovation. So I think that we're somewhere in between. Serbia is, of course, far behind. We have adopted in February last year the ethical guidance. It is something. It's like, I think it's a big step. Various civil society players and of course experts were involved in providing this sort of ethical guidance, and it does have major principles and also kind of self-assessment checklists for all the developers, so they can be used right now. So the people developing in Serbia right now at this moment some sort of AI-powered product, they could lean up on it and just go through the self-assessment and see what they should do to avoid maybe some sort of problems and issues in the future. So that's about it. I mean, I think that as in the case of GDPR, I know that because I was also following it very closely, we will be probably a bit behind, and most likely in 2 years after we have EU AI Act, we will have EU AI Act in Serbia. But at the end, even though we don't have a regulation right now, no one is having. I mean, AI is still not regulated even in EU, so we should just monitor closely and kind of follow and educate ourselves to be ready when it comes into force, because very soon and then we'll be in the process on preparing our own regulations on the AI.
Yes, definitely. Ethical guidelines are a step before
Exactly.
AI Act, and
Yeah.
it's a preparing of ecosystem for that
Yeah.
potential law. Okay, and are there any lawsuits worldwide due to privacy violations
Yeah.
resulting from the training and use of AI models?
Yeah, yeah, irrespective of this situation, like in this kind of limbo situation where we stand, we do have a lot of litigation, especially in the US. In European Union, of course, we don't, and in Serbia, apparently not. So in US, we do have a lot of litigation, and especially in the area of IP. So for IP infringement, all those cases are kind of concentrated in New York. While in California, there's a lot of. I think recently in September there was a second lawsuit for abuse of privacy in California. So there are more and more privacy concerned lawsuits, and the issues are bigger and bigger. And maybe the best let's say example is a Clearview, because the Clearview, one of the biggest facial recognition systems or companies in the world used by law enforcement agencies, they have been attracting the most attention. For the lawsuits against OpenAI, we still don't know. I mean, there's a lot of things to be discussed and to be assessed, whether there was or wasn't. I mean, whether there was a fair use principle on it or not. So this is something that is more complicated. For the Clearview, it's very, very easy to distinguish. They just did what they did. So they scraped a lot of faces from the social media accounts, and then they were using it to track and to recognize some of these people if they were under investigation or under suspicion of doing some crime. So a lot of us were around that. Even a lot of people were falsely, especially in Detroit, I think in 2020, one person was falsely accused or arrested. That was not for the Clearview case, but another facial recognition system. So a lot of biases can occur, especially from the facial recognition systems, and that's something that is really now attracting a lot of attention. And we will see, because at this point EU is kind of in a battle with what to do about it. Clearview, at the end, it was fined with 70 billion fine in the UK, but based on the jurisdictional grounds, proving that it was not actually used by the law enforcement in the UK, but by the law enforcement in US. They succeed in their appeal, and they were not charged with this such a big fine. They are again being fined in, I think, Greece and France and Italy. The fines are around 20 million euros, but they still were not implemented or enforced against them. So we don't know how this will end. And apparently we're living in a world with more and more lawsuits. So it's interesting to follow, to know, just to get some conclusions on how we're going to deal with it once we have our own regulations.
Thank you, Marija.
Thank you, Albert.
We will come back later at question and answers. I think it's 10 minutes. It will be enough after short introduction. Rania, can you introduce yourself, and let's say you are expert, but let's say a few sentences about you.
Sure, thank you. So my name is Rania Wazir. I'm a mathematician by training, and my focus is on trustworthy AI. How can we develop AI systems to make sure, basically, that they're fair, that they don't discriminate, and that they're transparent, which boils down actually to, do they actually work most of the time? So that's me in a nutshell. I think other things we'll figure out as long as we go along.
Okay. Marija mentioned also, and people talking a lot about the legal aspects of AI mostly, about the AI Act, first regulation on artificial intelligence, and let's say this first comprehensive AI law as a part of digital strategy. Please, can you tell us about priority that AI systems used in European Union must be safe, transparent, and non-discriminatory, etc.?
Yeah, well, from my point of view, it's actually amazing that we have AI systems. They are being used in very sensitive areas of our lives, and actually they're not regulated yet. So from my point of view, hallelujah, it's about time. And in particular, if we look at AI systems with significant impact, which is the way the AI Act is going, it's talking about risk, you have to look at, well, how does it impact people? And if you're going to use an AI system that will put someone in jail or decide if they get a loan or not, decide on their educational possibilities or what kind of a career they can have, you want to make sure that this system, A, works, that the person has some kind of recourse if there's failure of the system, you want accountability, somebody who's going to be responsible if something goes wrong, because without the accountability, you cannot enforce anything else. So I think those are the sort of the basic tenets of what's going on with the regulation. But what happens is then you get, the devil is in the details, and trying to work those out is turning very difficult, among other things, because there has to be a conversation between people from very different worlds. So you have the politicians, the legal experts, but you also need the technical people to explain what's possible and what's not.
If I may say something, for me it's a big problem that 27 countries must adopt that new law. You know, it must go through assembly, through government, and we must find good timing for that. You know, maybe you can adopt a law that there is not in good timing, and it's not. I don't know, we will see. But can you tell us what makes large language models different from other AI systems? Why are they such a stumbling block for regulation?
Well, so first of all, there is something a little different about AI systems in general, especially if we're talking about systems that are based on a lot of data and deep learning or other kinds of algorithms that are complex. Basically, we don't understand how they work. So it's very difficult to legislate about something when you're not really clear on how it works. What's happening with LLMs is that we've made them even bigger. So we have even more data and an even more complex algorithm underlying them. And what we're doing on top of that is building other applications on top. So we have a foundation that we don't really understand, and then we're putting an application on top. And so originally, at least my feeling when I read the draft AI Act was the people didn't understand how we build AI systems. And the basic assumption is that it's one model and it's produced by one company, and then there is one user. That's not how it works. And so you cannot put the whole responsibility on the producer, because who is the producer? And, you know, adding LLMs into this equation means the LLM doesn't have a direct application. You've built something on top of that. So if you take the person who built something on top of that and tell them you have to satisfy the regulation, well, they'll say, but I don't know what's happening with the LLM. I don't have all the information. I don't have all the access. So how can I satisfy all of the requirements. And so from my point of view, we need to rethink a little, we need to think a little bit about how we're spreading the accountability and the requirements so that they reflect the actual reality of how we build AI systems.
Thank you. Tell us more, let's say, what problems do AI systems that build on large language models face? And tell us more about the problems related to standards, transparency, and technical implementation of systems using LLMs. How can biases be detected in such cases, and who is accountable? You mentioned a little, but please explain us a little more. Thank you.
Okay. As I already said, you have applications, they're built on top of LLMs. Now, there is already research, I'm sure you'll talk about this more, Heiko, but LLMs themselves contain patterns that are our patterns and our cultural ways of doing things. And so we can't be very surprised if LLMs also contain biases. But trying to figure out exactly what those are and trying to figure out how to mitigate them is a whole other problem. Now, supposing you take an LLM and you build an AI system on top of that, what you're doing is aggregating biases because you have the bias that's coming in from the LLM, and then you'll have biases coming in from the way you designed the application on top of the LLM. So obviously, we're just making things more complex. And when we make things more complex, that also means we're more liable to make mistakes. And I say this because actually, this is part of my day job. I try to poke at systems and figure out where they're going wrong. And then in a second step, I try to figure out, well, what can I do to prevent them from going wrong? And I can tell you, it's very easy to make a system make a mistake. It's really hard to figure out how to avoid that. Wait, there was a second part to the question, sorry.
It was how can biases be detected in such cases, as who is accountable? And the first was more about the problems related to standards, transparency, and technical implementation of systems using large language models.
Okay. So the other side of that is if you want to regulate AI systems, you need to explain to people how to satisfy particular requirements. And so right now we've been operating on, okay, you build a system and you're going to regulate and put in rules. There's a gap, and that gap is called standards. You need to standardize a way to test the system. You need to standardize a way to be transparent about a system. You need to explain to people what does it mean for something to be explainable. And all of these things are actually happening behind the scenes. It's not very glorious, but you're not going to get a regulation if you don't have the standards in place. So what we have here is a technology which moves very fast. The regulations, which are slow, but what people don't realize is that actually the regulations are faster than the standards, because we're still in the phase of figuring out how do I test a system, and at what point can I say it's tested well and it's safe to use. And more than that, I would rather leave to question.
Heiko Hotz.
Hi.
Last but not least, welcome to Belgrade.
Thanks for having me.
Heiko, ladies first, Hotz. Can you introduce yourself, please?
Sure. So my name is Heiko. I'm the founder of NLP London, a non-for-profit meetup group in London where we connect NLP enthusiasts, businesses, and researchers all together in one room, because it turns out that NLP research goes ahead very quickly, as you probably are all aware, and businesses are a little bit left behind of like, okay, now there's a new model out, what does that actually help me? So that's NLP London. I'm also involved with DataKind UK, where we bring together charities and data scientists, because it turns out charities, they have lots and lots of data that they have collected over the years with their work, but they not necessarily have the expertise or the time or the money to deploy data science on top of that data in order to make sense of it, to make better decisions going forward. So at DataKind, we bring those two together, data scientists who want to volunteer their time and their expertise together with charities. And because none of those pay the bills, I also, during the day, work as a solutions architect at Amazon Web Services.
Thank you, Heiko. For the beginning, please explain us why and how large language models and also text-to-image models are based.
Yeah, so the reason why they're biased is, Rania already explained it, basically. They are trained on text data or on image data that has been scraped from somewhere on the internet. And as Marija said, you know, sometimes we don't even know, like, where does this data come from, who has consented to it. But basically, as you can imagine, all the text or images that are scraped from the internet, no matter from where, they contain our biases from our past. It's basically our written past in the internet. And if you train, turns out if you train a model on those, it will exactly copy those biases. Imagine, you know, taking teaching an AI model basically only on, let's say, racist texts. You can't be surprised if the resulting AI model then turns out to be racist.
Yes, Rania mentioned also how to overcome some of biases by carefully curating training data sets. What is your opinion, for example, how that big science initiative did it for the Bloom model?
Yeah, so everyone talks about mainly ChatGPT and OpenAI. I personally, by working also with other organizations, have actually high hopes for open source efforts in this space. So the Big Science Initiative, as a response to GPT-3 actually, not even ChatGPT, got together. It's a consortium of people who wanted to create a new data set, and in order to create that data set, it's basically an open source initiative. It was a one-year effort, I believe, from June 2021 to June 2022, where they had 1,000 collaborators coming together, all volunteers, in order to contribute data sets for a new language model. That language model then turned out to be the Bloom model, B-L-O-O-M. And the data set, I believe, contained 59 languages. So some of the biases are on genders, some of the biases are on races, but other biases we not necessarily think about is on languages. So a lot of the language models like ChatGPT are biased towards English. So the Big Science Initiative basically got together and created a multilingual data set. And that doesn't mean that you can eradicate excuse me, all these biases, but by being transparent, showing their work, at the very least, they can identify the biases that the resulting model has and point them out. And the model is available on the Hugging Face Model Hub, so everyone can download it. Everyone who wants to use it can read through the model card and say, okay, you know, I'm using this model. The producers of the model have remarked these are the biases that we have identified, and now it's on me as a consumer of this model of like, okay, I'm aware of these biases and I can take the risk, but at least I have that information, whereas with opaque proprietary models like ChatGPT, that is not the case.
Yes, definitely, biases are the big themes, and I want to ask you about consequences of these biases. Rania mentioned also in AI models and algorithms in general, what kind of consequences could appear using them, for example, in justice system or in areas of such as sentencing or predictive policing, parole.
Yeah, Rania again already touched on that. But these algorithms and AI models, and that is way before ChatGPT already, are being used to make decisions like sentencing or parole in the judicial system, or if you think about job hiring, AI systems are being deployed in order to determine which candidates are used for which jobs. Think about FICO scores, so financial scores, that basically condense all your information into one number, and then a decision is made based on this number. Now, the problem, in my opinion, is not necessarily that these algorithms and AI systems are being used. It is how much agency do we give these systems. What I mean by that is like, do we use these FICO scores, for example, these financial scores of a person blindly and just make automatic decisions based on those? Or do we use them, I like the phrase from the Microsoft country lead yesterday at the Data and AI Summit of like the age of co-pilots. Do we use these systems, do we use these models as co-pilots, as support, but still then question the result and still look on an individual basis of like, is this number correct? Like, should we give this person a loan or not? So there's two aspects, again, that I think are crucial. It's the fact how open and transparent are these models, or vice versa, how opaque are these, and how much agency do we give these models? Do we have feedback loops? Like, if we see that a model makes a wrong prediction, does a human go over this and say, no, this was actually wrong? And more importantly, do we feed that information back into the system so it can learn from its mistakes? Or do we just blindly accept, you know, a number that comes out of the machine and here you go?
Thank you, Heiko. And now it's time for audience for question and answers.
Thank you. Thank you, speakers, for the very interesting panel. It's also super important topics. I have a question for Rania primarily, but also Marija can maybe join in. It's a question about accountability. Rania, you mentioned some interesting points. First, we don't understand how these systems work. I fully agree. When we switch from the symbolic approach to the connectivistic to neural networks, deep learning, we have no way to backtrack exactly to which part of the system is responsible for making the concrete decisions. So following that, how can we actually enforce accountability, or how can we how can we know who or what or who is accountable? How do we solve the accountability problem with these kinds of models? Because we obviously need it even from the legal standpoint if it has a concrete impact on human lives. For example, if an autonomous vehicle tries to decide which there's a danger and it has to choose whether who to kill. Basically, how can we solve the accountability issues, or at least go in the right direction? Thank you.
Okay, well, wow, that's a hard question. I was telling him not to ask me evil questions. I should have included you as well. So the answer to that is I don't know. Okay, but it's about time that we acknowledged that we don't know, that it's a hard question, and it's not going to be solved by oversimplifying things, closing our eyes, and saying, just do it this way. And if you're going to hold someone accountable for a decision, you at least have to put them in the position to have made a real choice, right? So, and this was what I was saying is a lot of times the problem with LLMs. If I'm going to hold the end producer accountable, so the one who built on top of the LLM and put a product on the market, at minimum, this person should have been placed in the position to understand the LLM, at least in as far as it will affect their own system. How do you ensure that? And is that enough? Are you not placing like too great a burden, because the end producer tends to be a little company, and the LLM, well, who has the resources, unless you have big open source collaborations. Otherwise, you have a big tech company producing the LLM, and then the small companies building on top of that. Those are open questions. I don't have the answer to that.
Can I maybe add in? Well, as far as I was following, there's still it's unclear what will be the final standpoint in the EU AI Act. And I think that they are kind of leaning on, let's say, accountability or liability of the deployer. So the one that he will be in his own name, put the product on the market, or actually build upon it LLM and use it in its internal organization. As far as for the training, whatever happens during the training, of course, the developers will be liable. But when it gets out on the market, I think that most likely, as far as it looks like that to me, the deployers will be the one that will be considered liable. At the end, it does kind of also lean on our civil, or actually towards contracts and towards Act, and that kind of is systematic with it, because basically whoever that imports the product and puts it on the market, it will be liable. Then it will have a recourse towards somebody who has sold the product or the component that was not maybe safe enough. Of course, then we come to the questions Rania said, whether the importer or importer of a part of a product, in this case an LLM database, whether it was really informed of how does it work, what is inside, what kind of output it can give, but that will then remain within the contractual relationship between those two parties. So I think now we really don't know, but I think that as far as I have read, that it goes into direction that the deployers will be deployers, that the persons or entities putting on the market the products built upon the foundation models, that they will be the one that will be responsible towards the end users. Whereas on the other hand, for the training and for any kind of damages that can occur during the training on someone's data, will sit in and remain responsibility and liability of the developers. So that's something that I think it will go into that direction.
Heiko, do you want something to add?
No, I think
It's fair. It's fair.
I think I leave that to the legal experts.
Okay.
Alexander Buyanov, Head of DevOps. Thanks for the topic. It's really interesting for me. And my first question to Rania, 2 decades ago, or something like that, I heard the same point of view to the microprocessors regulations. We don't know how they works. And we build systems under them, on them. And we still don't know how it works. And there was about the security risk. You may include something in the microprocessor, and everything will be leaked after that. But after a few decades from the first mention, nothing changed, and nothing changed on the regulations, and we still have this problem, and everyone prefer to forget about it. Not everyone, but most of them, few companies still trying, and few governments. I think also in AI it will be regulated, but why do you think it's the different instead of microprocessors case? Because it's literally the same. What's changed in the area, and why do you think it will be regulated and something will be changed to the not evil side?
Okay, so first of all, I didn't know this microprocessor story. Please tell me about it later. But the point with AI is that its failures are visible, and so there has been enough negative publicity about AI system failures that people have certainly in the EU have decided we're going to try to intervene and protect fundamental rights. Well, there is another less, let's say, less kind view of why the EU is regulating AI. But let's stick with the kind view and say they really want to protect our fundamental rights. So yeah, the failures are visible. We've had a lot of publicity and articles and things out in the media. And fundamentally, if you want this technology to be adopted by people, you need to, okay, I'm not going to be kind. You need to at least pretend that you're doing something about it so that people will be willing to use it and accept it. Yeah.
I also have a question for Marija, but I will wait.
Of course, don't hijack the microphone, please.
Okay. And Marija, I have a question for you about regulation, because from my point of view, AI highly regulated in a few countries. It's highly regulated, but it's not regulated by regulation of AI. It's regulated by a regulation of IT systems. Yeah. And the problem for me, as a head of something, DevOps, but it doesn't matter, the problem is it's covered by another regulations. It doesn't fit AI. So for example, in most of banks' regulations in USA, for example, we have two-handed rule, which means which hand develop, it's not the same hand which support. So on production, another hand have to do everything with production, with data, with everything. And it really doesn't fit AI, because in AI, in big data, we have only production. We have no dev, test, everything separated, which we may give to developers and other guys and tech teams. And it's already regulated, but it's really hard to do. I know how to build it, it's possible, but it's really uncomfortable for everyone in the process. But why do you think it's about not regulated, but not about adaptation of current regulation? What do you think we will going to another new regulation pacts of everything, but not the change another one? I understand why it's because historic reasons and everything, but what's your point of view on it?
I think that they're probably okay. They opted for horizontal approach, to have one sort of regulation that will cover everything, and then most likely we will come to a situation that it just cannot cover everything equally because nothing's. I mean, there are various systems that are not the same. It doesn't fit in. So then they will probably end up with adopting or just amending already existing, I don't know, product safety regulations or something to try to also cover particularities of the system depending on the industry they're being used. So I think maybe just because at the moment they don't have enough time, so they want just to get something out, and maybe, as Rania said, from that didn't want to mention last kind of reasons, just to give some sort of stop a bit U.S. companies, or at least tell them, okay, as far as I'm trying to, catch you up, and I'm funding and I'm giving all these funds into various countries, including also Serbia, to just pump up the ecosystems of the startup ecosystems. I will just make you just to hold you back as much as I can by actually paying you license or making you pay a license of 6 million euros to come here and also do your stuff.
Okay.
And I think that maybe that's also the angle, and that's probably this was the fastest way to go with it, because I mean they can't just simply go ahead and regulate everything at the same time. So maybe that was the reason, just to put something out as soon as possible that maybe could be applied in the same way in all the industries, or actually in this a list of industries qualified by the risk that they could cause. But at the end, I think also that this will not work, because they will need to make differences for and they're also, even now, I don't know if you were following, they're trying to kind of they're lobbying to maybe make exceptions for use of, I don't know, RBIs for I don't know, enforcement purposes, or safety agency, internal safety agencies. Yeah, and they're trying to maybe to get something out from the application, or to exclude it from the application of the AI. So they're already kind of trying to do that by that sort of thing, by now lobbying before adopting a law. But I think at the end there must be another layer of regulation that will be more industry specific, because it's impossible to have one-stop shop approach for such a complicated thing.
Can I ask you a question? Since we have, regulatory
let's
experts
discuss.
here.
Yeah.
How do you regulate the open source community? So when we talk regulation, that usually applies to companies like Amazon, Google, OpenAI, Meta, but we are almost there that I myself can train a large language model, rather small, 7 billion, 13 billion, but quite capable already. How do you regulate that?
Probably this will come under the foundation models and the foundation, the let's say medium risk models, and they will not have that many onerous obligations. So at least transparency and that sort of things, I don't know, management, keeping all the logs automatically and stuff like that, but they will not be considered high risk. So I think that maybe they will fit into this definition, but I didn't see per se open source models being regulated or mentioned in the draft of the act.
I am certain that the questions, there will be many more questions, but
The question is the answer. I know how it relates to open source. So in open source, basically not the sources regulated, products regulated,
Yeah.
and few government regulate the quality checks and quality gates for the sources from open source. So if you use something out from inner source, you have obligation in your company to recheck everything which your community prepared for you. So if you're doing inner source, you check it because it's inside. So if you're using open source, you have obligation for government regulation in a few countries, surprisingly in Asia, I guess, to recheck it by some sort of code scanners, sometimes security scanners, and maybe by human inspection, but more formally. So That's how regulation work in open source in general. I think nothing new in AI, maybe in last year. I don't check last year.
All right, then. Yes. Well, I'm sure that you have more questions, but I'm also sure that you might be hungry. And what if we continue the conversation over lunch break?
This backstage.
Lunch break, yes. Then I would like to thank Heiko and Marija.
Thank you, everyone. Thank you
very much, and Rania. And thank you very